Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 115. We've got 3 cases for you, of course, in this podcast, but we've also got 2 concerts I went to see over the bank holiday weekend. It's been a while, I think, since I've said anything on that front, so as a quote-unquote reward for sticking with me to the end of the podcast, I'll tell you about my bank holiday weekend. The 3 cases, well, they cover the statutory right to be accompanied in disciplinary grievance hearings, the test for a fair process in a collective redundancy exercise where new jobs are being created rather than you're selecting a larger number of employees down to a smaller number of employees, and a case on stigma damages. As usual, you can access the podcast via iTunes. It's on the Mayor Brown website, YouTube, and the Twitter feed, Nicholas Robertson at Nicholas ROBER11, and that's where we have the links to the cases we are discussing. Without further ado, Green and London Borough of Barking and Dagenham. This was an unfair dismissal case dealing with what amounts to a fair process in a redundancy situation. And, well, look, the background to this is that the law relating to collective redundancy consultation and how it affects unfair dismissal has been the subject of many, many cases. The lead case for our purposes is Williams and Compare Maxim Limited. I think that's something like 35 years old now. In essence, these generally require an employer to give as much notice as possible of potential redundancies. Where collective consultation is required, the employer needs to consult the employee representatives with a view to agreeing the redundancy criteria that will be applied to the selected individuals. Those criteria should be as objective as far as possible, so they don't depend solely upon the opinion of the person making the selection, and the employer needs to make any selection fairly in accordance with this criteria. Finally, of course, the employer needs to consider alternative employment and alternatives to redundancy. As an oversimplification, where there are a number of redundancies to be made, this can usually be carried out in one of 2 ways. First, if the employer has, let's say, 50 employees and is looking this to reduce to, say, 30 employees, and they're all doing the same job for these purposes, the employer can apply redundancy selection criteria to whittle the 50 people down to 30, usually by choosing the 20 people who have the lowest scores against a particular redundancy criteria. In these circumstances, Williams and Compare Maxim is an obvious guide. You can have selection criteria, they can be as relatively objective, you can show that the markings were done in accordance with the selection criteria. However, the alternative approach which you've seen is that individuals are all placed at risk of redundancy and are made to reapply for the 30, in my example, continuing jobs. Selection may take place by interview and assessment rather than selection criteria. In those circumstances, how does the Williams and Compare Maxim case stack up? Well, in the background there's a case called Morgan and Welsh Rugby Union, where there was a new job being created following a reorganisation. Mr. Morgan was working one of the posts that disappeared in the reorganisation and didn't get the new job that was created. He claimed the process was unfair. This is in part because the panel that interviewed him did not apply the agreed procedure, although the Employment Tribunal felt that the procedure overall had been fair. He said, he pointed to Williams and Compare Maxim, it's necessary for selection to take place in accordance with the laid down criteria. The employer, in that case, the Morgan case, in essence said, look, we're making an internal appointment, and so there's a greater degree of latitude given to employers to appoint the person they think is the best person for the job. The AT backed the employer, not the employee. In summary, Morgan acknowledged that an employer's assessment of which candidate will be the best for the new role is likely to involve a substantial element of judgment, and as such, this seemed to indicate that employers had rather more leeway under the Morgan-type situation than the Williams and Compare Maxim situation. You may think there's a slight tension between these 2 approaches. Well, in the Green case, the case for this podcast, what happened was that the claimant worked in a position graded as PO6. There were 3 people in the same grade. In 2012, as part of a reorganisation process, these 3 PO6 jobs were eliminated and 2 new PO6 posts were created, which were going to be filled by an unseen written test and an interview. At the same time, a lower graded post, PO4, was eliminated and a new PO5 position was created. In essence, the employer provided a preliminary process under which, if your old job matched the new vacant job by more than a particular percentage, then you're automatically considered for the role. Below a certain percentage, you wouldn't be considered for the role. The person who was in the lower role, the PO4 role, applied for and was given the PO5 role. The claimant, however, lost out on the PO6 roles. She claimed the process was unfair, but the tribunal, purporting to rely on the Morgan case, said that this was not a classic redundancy situation. Williams and Compare Maxim applied to a situation where reducing the number of roles, where you were reducing the number of roles, not where you were creating new roles. This case, the Green case, was equivalent to a recruitment, and therefore, the Employment Tribunal said, in line with Morgan, the Employment Tribunal gave a lot of weight to the fact that recruiting managers knew what they were looking for and pushed aside a number of the employees' concerns about the process that had been adopted. The claimant's case was that the selection process that was adopted was flawed in a number of ways. For example, she claimed that the scenario that had to be answered in the written part of the test was based on a project known to one of the other candidates. She said the employer's process called for top-down when it came to filling roles, so that meant the PO6 positions should have been filled before the PO5 position was filled. This didn't happen, and the result was that the claimant was then unable to apply for the PO5 role before it was given to the candidate from the PO4 job that was being made redundant. However, given that the Employment Tribunal took a very hands-off approach, the claimant lost her case. She appealed. The EAT came down firmly against the employer. They said that this was not really the creation of a brand new job at the PO6 level, but was in fact factually closer to a situation where 3 jobs were being reduced to 2. In any event, they said, the Morgan case did not offer a different test for a fair dismissal. It reminded tribunals, the EAT said, that they needed to apply the basic unfair dismissal test laid down in section 98(4), and they needed to test whether there was a fair process. In my terms, the Employment Tribunal had been too hands-off in the EAT's view. Thus, the EAT felt the Tribunal had failed to consider whether it was right that the claimant should have been denied a right of appeal by the employer against the decision not to appoint her. Similarly, the Tribunal failed to deal with the claimant's argument that the collective consultation exercise had been sufficiently poor that this made the dismissal unfair. At the end of the day, the Tribunal decision was overturned on ordinary unfair dismissal and sent back for reconsideration. My reason for including this in the podcast, I think it does lay a bit of a fallacy to rest. Both Williams and Compare Maxim and the Morgan case deal with the basic test, statutory test for unfair dismissal. In truth, Morgan acknowledges that where a new job is created, it may not be possible to apply the same rigid objective selection criteria that you would look to apply if you're selecting a number of employees out of a larger pool for redundancy. However, the claimant can still expect the employer to follow a fair procedure before it finds a dismissal is fair. In practical terms, I think this means that employers need to be able to justify the selection of, or the appointment, I should say, of a successful candidate into a new role. It's not a lesser test. It's simply a recognition, however, and the tribunals do recognise this, that how someone performs at an interview may not be capable of explicit objective proof to a tribunal. Nonetheless, the tribunal will be entitled to expect the employer to be able to explain its decision, either by reference to particular answers or experience or some other evidence, so that it's not just totally at the whim of the person making the appointment. So, that's the case of Green and London Borough of Barking and Dagenham. Next up, and with apologies to the claimant, Nahoua, which is GNAHOUA, and Abellio London Limited. Under the Employment Relations Act, workers have a right to be accompanied to a disciplinary or grievance hearing. If the employee reasonably requests to be accompanied at the hearing, then the employer, according to Section 10 of the Act, must permit the worker to be accompanied by the chosen companion, and must permit the companion to address the disciplinary or grievance meeting, and to confer with the worker during the disciplinary and grievance hearing. The relevant person, in these cases, is either a work colleague of the worker who's going through the process, or an official of a trade union. Obviously, the trade union itself does not need to be recognised by the employer. Originally, when the legislation was passed, most people and ACAS thought the reference to the employee reasonably requesting to be accompanied at the hearing meant that the employer had a residual discretion to reject the companion chosen by the individual if it wasn't reasonable. However, in a case a few years back called Toll, TOAL, and GB Oils Limited, the EAT had decided the choice of companion itself did not have to be a reasonable one. In other words, the employee has the freedom to choose who they want. Obviously, of course, if they're choosing a work colleague, the work colleague is under no obligation to agree to represent them. Here, the facts are about as extreme as possible. Disciplinary action was commenced against the claimant. He was dismissed. He wanted to appeal internally through the company's process, and he went to the PTSC union, which apparently, according to the case report, has a reputation as being one that will put up a robust defence on behalf of its members facing disciplinary or grievance proceedings. The two main individuals who set up the union are clearly robust characters, and they were proposing to represent the claimant at the appeal hearing. The company, for reasons which I will explain in a moment, refused to allow them to attend the claimant's hearing, and the claimant was dismissed. His appeal was rejected. So why didn't the company allow the two officials to attend? Well, one of them was a former employee, I should say, and had been dismissed by the company for harassment and intimidation of a member of staff. He'd then been banned from the premises and had threatened a manager to the extent the police had to be called. The other one represented his brother in the tribunal proceedings that followed his brother's dismissal. Those tribunal proceedings were struck out because, according to the AT, the pair of them had engaged in vexatious conduct, which included, apparently, falsifying a date on which a witness statement had been prepared. As a result, £10,000 in costs were awarded against the two brothers. So, as I say, the facts could not be clearer that the company had very good grounds for saying it was inappropriate to allow these individuals into the disciplinary hearing as representatives for the claimant. Did that make a difference? Well, sort of, was the answer. The Employment Tribunal found that the case law clearly established that there was an unfettered right for the employee to choose the companion. It could not be said, of course, that it was unreasonable for the individual to want a companion in the hearing. Therefore, there was a breach of Section 10. However, the tribunal went on to say there was no loss or detriment suffered by the claimant, and so he won the princely sum of £2, count them, 1-2, at the end of the day. I think it's important to keep the case in perspective, although it's helpful in parts. It's a tribunal case, it's an employment tribunal case rather than an appeal court case. It's another case that confirms that an employee has an absolute right to ask for whoever they want, either as a working colleague or if they're a union official to attend. Failure to allow this person to attend will amount to a detriment. Secondly, however, this tribunal took a very pragmatic approach in awarding nominal compensation. I wonder whether a tribunal will always be so convinced that there was no detriment suffered by an employee who is denied his or her companion of choice just because the companion of choice is going to be particularly robust with the employer. I imagine, given the law in this area, was quite clear, and the tribunal obviously had a view of things, that they found a way to come to what they felt was a just result overall. So, in summary, an employee who is facing a disciplinary or grievance hearing can choose any work colleague or any union official to attend, and employers will need to think very carefully about rejecting those companions. In extreme case, it might make sense to do so, but it will not necessarily follow that a tribunal will come to the same robust decision that this one did. So that's the case of Nahoa and Abellio London Limited. Third and final case, Small and Shrewsbury and Telford Hospital NHS Trust. I thought this case was worth putting into the podcast because it flags the issue of stigma damages. In a practical sense, I don't think the case says anything new, and I wanted to use it to show the fact pattern and where stigma damages might come into play. The case carries on, so there are no final determinations. Having dealt with the law in relation to each of the first two cases in this podcast, let me do things the other way around, tell you the facts, and then we'll apply the law to them. The employee, the claimant, was a project manager. He was engaged expressly on a short-term contract, although one of the things he was claiming at the subsequent tribunal hearing was that he would have been offered permanent employment, which he would retain until he retired in 2022. He was dismissed and wanted to claim for damages based on an employment end date of 2022. His witness statement also, however, contained reference to the fact that he was prejudiced from obtaining alternative employment because the employer wouldn't give him a reference. He'd applied for something like 600 jobs by this stage. He said the stigma of being dismissed and bringing a tribunal claim were conspiring against him. The tribunal found that he would not have been employed on a permanent basis, so capped the loss period at November 2013, which is when his replacement had left. Well, Mr. Small appealed against the Employment Tribunal decision, saying that the compensation period should have been longer. One of the things that the EAT was asked to consider was whether the stigma damages claim should have been considered by the Employment Tribunal of its own motion, given the evidence that had been put in front of them. The background is that a stigma damages claim is one based on any detriment suffered by a successful claimant in the job market if they've been unfairly dismissed or have sued the employer, have brought a tribunal claim against the employer. In principle, if the employer does cause loss to an employee in this way, that is potentially capable of being recovered in a successful tribunal claim. Here, the argument was that the claimant would suffer loss after November 2013 because of what the employer had done. Well, the case went up to the Court of Appeal, where the argument, as I say, centred on whether the tribunal had been put on notice sufficiently that there was a stigma damages claim, so they should have taken up matters themselves to come to a decision on that point. And in essence, the Court of Appeal decided that it was arguable his losses continued beyond November 2013 in view of the evidence he provided. As such, even though he was only employed on a short-term basis and his replacement had left within a year or so of him leaving, his loss period could go beyond those dates. If you're running the numbers, whether for the employer in the face of a claim or for a claimant, I think it's easy to overlook stigma damages. That said, in practice, it is very difficult to get evidence of stigma damages. I remember when the last big case on this subject came out, which was the Abbey National and Chagga case, we indicated, in fact I may have talked about it on the podcast, we indicated that we thought there would be a lot more stigma damages claims, but in practice this has not tended to happen. But it doesn't mean that this case is not an important one. Tribunals should be alert to evidence that indicate a stigma damages claim, and employers should, if they're doing a risk analysis or an evaluation of the loss period, should bear this in mind too. And here, he clearly has some evidence. If he has made 600 jobs, that sounds like an awful lot of jobs if you're applying for a new post, an awful lot of jobs to be applying for without any success. Anyway, as I say, the case continues, so it'll be interesting to see what comes up there. So there we go. Thank you very much for listening to episode 115. I promised you short to update on the cultural front. So Saturday night, last Saturday, I was at the London Palladium to see Bob Dylan play. He was amazing. I went with very low expectations, it must be said. I've seen him many, many times in concert, and there's always moments of genius and quite a few moments of slapdash stuff. On this occasion, he was great throughout, and that's despite the fact that he was doing a lot of his newer material, which is less to my taste. But live, it comes across as an incredibly sympathetic presentation. So if you get a chance, go see him. I wouldn't recommend seeing him if you haven't seen him before, but if you've seen him before, he's definitely worth going to see again. And then on the Sunday night, I went and saw Jim Moray play at an open-air folk festival, and he was equally good. First time I've seen him, really talented, and a really nice chap. I spoke to him briefly afterwards because he does a podcast series, so after I'd said how great I thought his show was, we talked about the challenges of doing podcast series and getting up the nerve to do that. So yes, if you get a chance to go see him, strongly recommend him too. So there we go. That's enough on the cultural front. I think it only remains for me to confirm that at no point in the recording of this podcast were any mugwumps elected to Parliament. Thank you very much.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.